Do you have an IRA with Merrill Lynch? If you do, you probably want to reconsider that. And why do I say that? Well, let me explain why. There was a recent court decision that came out, I believe is in October of last year, and it's absolutely mind-boggling to me that this hasn't received more press. But here's what happened. And this was a bankruptcy court case, and this is going to be very important. In this bankruptcy court case, the bankruptcy judge said that an IRA that was held by Merrill Lynch and invested by Merrill Lynch no longer was considered an exempt asset. And let me give you a little bit of background. Typically, retirement plans, if you go bankrupt or if a creditor comes running after you, let's say that you did a short sale and the second didn't release its claim against you, typically your retirement plans are going to be considered something called exempt assets. And that means not only are they exempt from taxes, but they're also exempt from the claims of creditors. Now, whenever you file bankruptcy, you have to list a complete list of all the assets that you own, and then you're allowed to say, but we believe this particular asset is exempt. And that's what happens with most people and their IRA accounts, is they list their asset as exempt. They list their IRA as exempt. Now, here's the challenge, though. The federal laws and most state laws say your IRA is only exempt. That means not subject to the claims of your creditors, not subject to the claims of the bankruptcy trustee. Your IRA is only exempt if it meets the tax code qualifications of being an IRA. In particular, for Tennessee, Tennessee's code section about whether a retirement plan is exempt or not says a retirement plan which is qualified under Section 408, and Section 408 is the key section of the code dealing with the key section of the tax code dealing with the exempt status of IRAs, are exempt from any and all claims of creditors of the participant or beneficiary except the state of Tennessee. So, in other words, if the IRA is qualified and meets the definition of an IRA under the tax code, it's exempt from all creditors in Tennessee. But here's the challenge. There's all sorts of weird rules for IRAs, and most brokerage firms ignore these weird rules. In particular, there's a key section of the Internal Revenue Code that says if you violate this section, your IRA is no longer qualified under that Section 408. And remember, your IRA has to be qualified under 408 in order to be considered an exempt asset in Tennessee. So what are these weird rules? And let's just go into the most important one, really. Lending of money or other extension of credit between a plan and a disqualified person. Lending of money or other extension of credit between a plan and a disqualified person. So if you engage in a loan between you and your IRA, then your IRA is going to be considered disqualified. Or if you don't do a loan, you do an extension of credit between a retirement plan and yourself, that's going to cause your IRA to be disqualified also. But that's kind of weird sounding. Extension of credit. What does that mean? Well, the government has taken the position that if you provide a guarantee, if you guarantee the funds inside of your IRA, if you promise to indemnify a brokerage firm from losses inside your IRA, that's considered an extension of credit. In particular, the Department of Labor, who's in charge of determining if an extension of credit will blow up an IRA, the Department of Labor came out with a ruling, and here it is black and white. It says, it's the opinion of the department that the grant by an IRA owner to the broker of a security interest in his non-IRA accounts in order to cover indebtedness of or arising from his IRA as you describe would be a prohibited transaction. And let me try to translate this. If the IRA owner promises to make good on any debts of the IRA or pledges any of their non-IRA assets for the benefit of the IRA, that's going to cause the IRA to lose its tax qualified status. And if it loses its tax qualified status, it loses its exempt status. Okay, let's go full circle. Why did I say you might have some issues if you have an IRA with Merrill Lynch? Here's why I said that. As part of Merrill Lynch's standard paperwork, they have a provision, and I believe they've changed this, but if you opened it before December of 2010, you probably need to be careful. And it says all of your securities and other property in any account, margin or cash, in which you have an interest or which at any time are in your possession or under your control, shall be subject to a lien for the discharge of any and all indebtedness or any other obligations you may have to Merrill Lynch. Translation: if you have any accounts other than IRA accounts, you are agreeing to pledge those accounts to grant a lien on those accounts to Merrill Lynch in case your IRA goes south. Now, it doesn't matter that your IRA is never going to go to south, because it's almost impossible for an IRA to end up in the negative. But Merrill Lynch still required people to agree to this language, saying they grant Merrill Lynch a lien on these assets. And by the way, Merrill Lynch has tried to go after people on this language too. In fact, has even tried to go after people's IRAs. It's astounding. So the bankruptcy judge, they looked at this language. They looked at the ruling from the Department of Labor, and they said, you know what? This is absolutely mind-boggling. And they really had some fascinating language inside here. Where was it? Oh, here it is. And I can't pronounce this next word, guys. You're going to have to forgive me. It says, and I'm just going to say weird as it appears, based upon the client relationship agreement signed by the debtor, the mere opening of the Merrill Lynch IRA caused the debtor to participate in a prohibited transaction under 4975. Since the debtor engaged in this prohibited transaction under 4975, if we scroll on down to the bottom line, the judge determined the debtor wasn't entitled to keep their $61,646 IRA. Instead, that had lost its tax exempt status, and it had lost its exempt status from the claims of creditors. So, how does this affect you? The language that was inside this account agreement is pretty much standard language in Merrill Lynch's account agreements. If you opened up an IRA before December 2010, there's a very high likelihood that a federal court could follow this federal court and determine that your IRA is no longer an IRA, it's fully distributed, and to add salt to the wounds here, that it could be subject to the claims of your creditors, or if you have to go bankrupt, your bankruptcy trustee could take it away. Steps to take. What's the action items? What's the takeaway from this video? The takeaway is this. If you have an IRA with Merrill Lynch, you have got to check into this immediately, and you might want to consider moving that IRA to safer ground, or contacting the IRS, contacting the Department of Labor, and seeing what steps you can take to make sure your IRA is in good standing. If you have any questions, feel free to contact us at www.planblaw.com. Thank you very much.